Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to the latest episode of the Dealmaking with Laura DiFrancesco podcast. I'm your host, Laura DiFrancesco, founder of Dean Street Law, an M&A law firm, as well as author of the book, Entrepreneurship Through Acquisition, a legal guide to buying a small business. Today's episode is all about how we communicate with clients in mergers and acquisitions. And this can be very different from client to client. Every single client has different priorities and preferences around communication. So we do customize this from client to client, but we wanted to share both with prospective clients as well as current clients how we communicate. So the first and most important thing is that our priority is exceptional customer service and supporting you in the deal making process. So you'll find that while we like to set expectations, we both work with customer preferences, client preferences, as well as what's actually going on with the deal and how do we respond. But let's just set the stage with some general expectations. So as soon as you receive a proposal and engagement letter with us, we communicate our expectations around communication. So first off, best ways to communicate with us. And we also reiterate this and expand upon it within our welcome packet and welcome letter that you'll receive from us. But just to go over it in general, the best way for regular communication is going to be via email. Some folks try to text message us, but we only have our business manager who has our company phone. And then sometimes I have our company phone as well. So text messages aren't going to be the best way to get a hold of us. Email is the best way. And you're always going to email your attorneys, me, and you'll have my email address, and maybe also any of our other attorneys on our team, as well as our team, which is admin@deanstreetlaw.com. And we always ask that you copy our team, admin@deanstreetlaw.com, to make sure that our team is abreast of all information. As you know, when you're buying or selling a business, when you're involved in mergers and acquisitions, time moves quickly. And we want to make sure that information management is one of our top priorities as your firm, because so many different nuances within a deal are going to change depending on the information that we have. And so keeping information transparent throughout our entire team is super important. That's why we always ask for our clients to use email as our primary communication, and then copy not only your attorneys, but also admin@deanstreetlaw.com so that we don't miss any messages. We can best serve you and we can work as quickly as possible. We don't want to delay something if I'm in meetings and then I don't see your email until the afternoon, when in fact our team could have been working on it from the morning when you sent the email. So that's a priority to us. And then we love phone calls. Phone calls are the best way to talk through meaty issues. You're going to have negotiations back and forth, and those are going to be best talked about like when we receive a slew of comments. Let's talk through those, because phone calls give us the opportunity to ask clarifying questions, to weigh your responses. You may have a certain amount of risk tolerance, or you may have something in the deal that's a really important deal term for you, and maybe we can give here to get there. And so I feel like we can have a much more fluid conversation when we're talking about deal terms in a phone conversation. So I always love to set those up. You can always book through my Calendly as a client. You have access to that both in your welcome package and emails, as well as I think it's probably also in my email signature as well. So you can book a call with us through Calendly or just email us and ask for a call. You're welcome to call the office if you'd like to try to set up an impromptu call, but I will say most of my day is scheduled out between deep work and my business manager has the phone or I'm on a client call. So it is sometimes a little bit harder, but always if something's urgent, give us a call, send us an email, we'll get back to you immediately. We do know that deals move quickly, but we like to just share the best ways to communicate with us because information management is top of mind, a priority for us. In addition to that, client-lawyer relationships. So anything communicated to us is confidential, whether you are a prospective client sharing an LOI with us or you are a current client and we're going through deal documents. There is laws that protect client confidentiality, and we also have confidentiality notices you'll find on all of our emails as well. So you can feel comfortable that not only do we have practices set forth in our law firm to ensure your confidentiality, but it's also a legal requirement for us as well. So we don't need to sign non-disclosure agreements. Your confidential information is safe with us. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. With respect to timing, availability, we talked about preferred methods. Generally for a quick call, if I'm working on a document and I have an issue and I want to make sure I can get that document out to you today or it's time sensitive, I'm going to give you a call. And if you have time for it, amazing. If not, no big deal. Most days, the vast majority of the days, I'm going to be able to, or an attorney on our team is going to be able to jump on a call same day. But we love to work proactively. That is at the heart of our work at Dean Street Law, because the best legal services for you are proactive legal services, because we want to be anticipating things and spending the time and energy appropriate to it. When we talk about an issue, I'm thinking about it after that time that we talk about an issue. And I may come up with 3 or 4 more solutions before our next conversation, right? So time on our side is always going to drastically benefit you. Whenever we can have communications around timing and expectations, and we know things sooner rather than later, sooner that something's coming down the pipeline, that will always benefit you. So we ask that our clients be as conscientious as they can to keep us in the loop. First, make sure that you're sharing all information on the deal that you can with us, because even things such as conversations with you, if you're on the buy side, conversations with your quality of earnings provider, or if you're on the sell side, conversations with your accountant and tax preparer for tax strategy, all of those are going to impact the transaction. So we want to make sure that we have as much access to information as possible so that we can provide the best services, but also keep us in the loop on things like timing. Like, are you going to be on vacation for a week at this time? So you're going to need documents before that time, or you're going to be available to look at documents after that time, or what's your expectation on timeline to closing? And even so much as just when you engage us, the sooner that you engage us, the better, because the more time that you have for the process, the better it's going to enable you to get the deal done in the least stressful way, and also enable us to spend as much time as we can on each phase of the transaction so that you're getting the most value out of our representation. And then it's as simple as, if you want to have a call, always happy to have a call. It is helpful though to know what you want to have a call about and the questions that you want to ask. So if you have like 3 or 4 questions and you want to send an email and then we can schedule a call, that's best case scenario, because I can only be so helpful to you on the fly. I obviously have a lot of experience and I'm going to be able to give you responses in broad strokes, but there may be things that we might need to look at in a contract or in a regulation or something like that, where it's going to be a lot more efficient for you and my time to be able to have the questions up front, to know what we're going to be talking about, so then I can come to the meeting prepared and best utilize your time. And then, of course, when you engage us, it will help as well. Even if you're just thinking, hey, I'm going to be, hiring counsel in 2 weeks. I have an LOI that I'm negotiating. I just want to put this on your radar so that you can plan for it. It's always easier for us to reserve capacity for you and your projects than it will be to add it, last minute. We did have a couple of clients who engaged us in December for an end of the year closing. And we told them we would work our hardest to assist them, but ultimately we can't control the response times of everybody else on the deal. So while we respond quickly, work quickly on our projects, we can't control opposing counsel and how quickly they're going to work on their projects. So whenever we can, getting started as soon as possible is great. And then also, the cadence of communication will change as we get further into the deal. In an LOI, it's very quick communication because it's a competitive situation. We want to make sure that you're getting that done as soon as possible. And then a lot of it's going to start lengthening cadence times because we like to have a weekly meeting with all of our clients once they're under LOI. Because I think that's a great opportunity to stay in touch. We'll have our agenda, you'll have yours, and we'll make sure that we touch base and each party is moving forward the transaction. You know what to expect. You know what we're working on. Overall, I feel like that generally works best for most, but it is optional. If you don't want that, that's totally fine. We can do it more ad hoc. But then when you see, once we send out a due diligence request list, if we're on the buy side or something like that, then it's going to take the seller some time to respond to that. Or if you're on the sell side and, you're receiving a due diligence request list, it's going to take time to start populating all of that information. So the cadence of things kind of slows down a little bit in the middle, and then it'll speed back up again once you get towards closing. We like to make sure that we're balancing clear, simple communication, keeping you informed without overwhelming you. We always want to break down hard, complex ideas, things of like a F reorganization or tax consequences, into easy, digestible communications. And then in terms of what do we bring to the surface versus what do we handle behind the scenes, anything that is a deal term, you're going to be involved with. You are the decision maker. Even if it's something as simple as notice provisions, I'm going to flag it for you, say, we think this is okay. What are your thoughts? Ultimately, you're the deciding factor. You're the decision maker on a transaction. We're here to support you. We're here to advise you on what the pros and cons are, what the risks are, what risk mitigation strategies we can implement, but ultimately you're the decider. And then we like to make sure that we do use all the tools available to us. Most of the time we are recording a video, or rather a call or something like that, so that we can triple check everything that you said. We talk about this in our engagement letter, in our welcome letter, in our welcome packet. And then if you ever want to opt out of that, just let us know. That's totally fine. But that is our preference, to be able to record our conversations that are confidential so that we can then go back. Let's say I had a question about specifically how you phrased something. Instead of me using my notes that would have summarized that, and I might have not been clear on implementing exactly the term that you wanted, I can then refer back to my notes, the call recording and the notes from that, to make sure that I'm implementing it exactly as is. And then I go through literally line by line of my notes and the call to make sure that we're implementing everything that we discussed. So our goal is to make everything as seamless for you as possible, give you the greatest likelihood of success. Obviously, not everything is within our realm of control, but I know that we can significantly influence likelihood of success, timing, communication. And that's just as simple as, in the very beginning of a deal, we're going to put together a closing checklist and timeline and send it to everybody so everybody knows what to expect at different times of the transaction timeline, what we're going to need to hit by when in order to close on time. Being proactive, being communicative is, in my opinion, one of our greatest strengths because it enables us to best influence the likelihood of success for our clients. So if you'd like to work with us, we'd love to hear from you. You can schedule a consultation call through the link in our show notes or deanstreetlaw.com/links. And be sure to let me know, what would you like to see in the next episode? Thank you so much. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us. And share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal making.